Yes, Mr. Mobley.
Good morning. I'm appearing this morning with Mr. Simpson. I'm only friends Mr. Mitchell and Mr. Medcroft appearing before the respondent bank. I was proposing to structure my submissions today to deal first with the law, secondly then look briefly at the claim and a response to it, then consider the first instance judgment and the appeal judgment and what we say in relation to them, and finally look at the points raised by the bank and our answers to them if there's sufficient time. If that's a convenient course.
Yes, certainly.
Thank you. The issue for the board is whether in refusing to grant a retrial, the Court of Appeal erred in principle and has accordingly delivered an injustice to the claimants. We use those words because those are the words used by Justice of Appeal Reimer in the Court of Appeal in the Lavarello and Giska Bank case in determining a consequence if no retrial was ordered in that case. The Giska Bank actions closely related to this action involved the same underlying fraud by Marachi & Co., the firm of solicitors in Gibraltar, who banked with both Giska Bank and the Royal Bank of Scotland, involved the same type of claim, a claim alleging dishonest assistance. The same first instance judge and largely the same Court of Appeal. We consider it an important and highly relevant decision for present purposes, and obviously we'll return to that in a moment. As far as legal principle is concerned, we have to confess finding legal principle has proved rather problematic. There are obviously a myriad of cases where a retrial is ordered by the appellate court, but in none of those cases have we found a clear statement of principle as to the circumstances in which a retrial should be ordered. One or two cases that make self-evident propositions like a retrial is expensive and delaying a delay to justice and a remedy of last resort, and obviously we don't cavil with those, but that doesn't really take the matter very much further forward. The only case learned friends really rely on is the White and White case, and that simply makes those sort of points. We refer in our case to two cases which, by way of example, show how the appellate court approaches retrials. The first is the Chen case. Chen and Ng, it was an appeal from the Court of Appeal in the British Virgin Islands, a dispute about the ownership of shares in the BVI company, which owed the Macau hotel. The claimant in that case was a Mr. Ng. He had transferred some shares to the defendant, Madam Cheng, and he said it was on a temporary basis. He had a bad reputation. He needed Madam Cheng to front up an application for planning permission for another hotel in Macau, and for that she needed to show substantial assets, and therefore the shares were transferred to her. So that was his story. He executed a share transfer that said the shares were being transferred in consideration of $40,000, but no sum was actually paid. So that gave rise to a number of issues. First of all, was there contractual liability to pay the $40,000? If there wasn't such a contractual liability, there was then no contract. And the question then was there a resulting trust in favour of Mr. Ng or a gift to Madam Chen? That's what the board concluded were the issues in that case. The problem was that none of those issues were explored at trial, and the judge rejected everybody's case and found against Mr. Ng on the basis, first of all, his explanation was incredible about planning permission and Mrs. Ng fronting that, because his name was all over the planning documents. Secondly, that if he'd wanted to transfer shares on a temporary basis, he would have obtained a blank stock transfer form. He hadn't done so, and therefore, on that basis, the learned judge found he couldn't have intended to transfer the shares only on a temporary basis. But as I say, neither of those points were put to Mr. Ng. If I can take you to the case to see what the Privy Council decided in those circumstances, it's at page 3572 of the electronic bundle, which is, I think, tab 2 of the authorities. And if you look at paragraph 61, the board there summarised the problems, that the relevant issues were central to the whole proceedings, but neither ground which the judge gave for disbelieving Mr. Ung was put to Mr. Ung, neither ground was referred to at hearing at any time, and neither ground was obscure or difficult, and it's quite possible that Mr. Ung would have been able to give believable evidence, and there's nothing in the judgment which can be invoked to say that it's reasonably clear the judge would have reached the same conclusion without those grounds. So in those circumstances, you can see what the board did at paragraph 62. It first of all found that the judge's decision couldn't stand, and it then said that the issue as to which the possibilities might apply needed further consideration in the light of the evidence. It concluded that it was self-evidently not possible for the board to reach a conclusion on the issue of Mr. Ung's credibility, and therefore the only possible outcome was that the case should be sent back for a rehearing. So that's what they decided in the Chung case. A case that goes in the opposite direction is the Alham Rami case, which you'll find at tab 1 of the authorities bundle, electronic bundle, page 354 is where it starts. 3524, I should say, sorry. What happened is apparent from 3527. Essentially, the question was whether a contract for the sale of shares governed by Saudi Arabian law included shares in a particular company, Chemtrade. There was a lengthy trial before Justice Bannister in the Virgin Islands. He concluded that the answer was that the shares were not included. It went to the Court of Appeal, who reached the opposite conclusion. You can see this from paragraph 5. And the unsuccessful claimants invited the board to reverse the decision of the Court of Appeal. If you turn through to paragraph 18 on page 3532, see that the issue was as to the application of the law of Saudi Arabia to the relevant contract. And then turning through to paragraph 27, you can see that the board approached it by saying, so this is page 3535, the proper meaning of the contract governed by foreign law is not a finding of primary fact, which an appeal court is particularly cautious about overturning. In view of the advantage of the trial court in seeing and hearing of witnesses, it's an application to the primary facts of the principles of interpretation of the foreign law identified by the experts, an exercise that the appeal court, whether it's the Court of Appeal or the board, is in as good a position to carry out as the trial judge. And with that approach, if you turn through to page 3547 at paragraph 64, there was a consideration about whether or not there should be a retrial. The suggestion was rejected on the basis that the Court of Appeal was entitled to reach the conclusion it did, which it wouldn't be appropriate for the board to interfere with, and the board in any event wouldn't order a retrial. What's really an issue is the proper inference to be drawn from undisputed facts. The board and the Court of Appeal in a position to draw an appropriate inference without a further trial. So there's a case going in the opposite direction. The third case I wanted to take you to is the Giska case I mentioned earlier. You find that at page 3574. And just to put this into context, it also, as I've said before, revolved around the Marachi fraud. It again involved an account manager, in this case a Mr. Bishop in Giska Bank, And the sole issue was whether he knew or suspected between 2003 and 2009 that various transactions involved the Marazzi brothers stealing money from the client accounts. The judge decided, by reference to a series of transactions, that he did have either actual or blind eye knowledge of the thefts. There was an appeal to the Court of Appeal, as I say, essentially the same Court of Appeal as we have in our case, and they were successful. If I just show you the sort of errors that were made by the judge in the Giska case, by reference to, first of all, paragraph 87, which is at page 3618. The first error that the judge committed was to assess the honesty of Mr. Bishop, the manager, by reference to his own determination of what a reasonable banker would or wouldn't have done, and therefore ignored the expert evidence that had been adduced. And you can see at page 3630, paragraph 109, that the Justice of Appeal Reimer concluded that he should have taken into account expert evidence. There were then a series of challenges to findings of fact. You can see those starting at paragraph 113. At 3632. And there's been a detailed examination of various issues. If you turn through, you can see at 3634 a question of the demeanour of Mr. Bishop in giving his evidence. There's then a consideration of the motive that Mr. Bishop might have had for giving dishonest assistance to the Marazzis. There's then an issue about what Mr. Bishop knew of the client accounts that starts at page 3639, paragraph 127 onwards. And then a further issue as to whether Mr. Bishop was unquestionably carrying out instructions from the firm. And that was 3648. You can see that being considered there. And so those are the issues. So there's one further issue, which is in relation to whether or not Mr. Bishop had lied in describing various bonds that didn't belong to the firm as assets of the firm in relation to an audit. Those were the issues. They were considered by Justice of Appeal Reimer from paragraph 160 onwards, where he draws his conclusions. That's page 3655. He first of all deals with demeanour, and I just invite you to note at paragraph 161, he says assessment of demeanour is not an assessment of the words used as much as how they are used, and the Court of Appeal is in no position to know what it was about these particular answers that caused the judge to single them out for comment. So that's relevant because obviously in our case, one of the issues is the demeanour of Mr. Shaw in giving his evidence. And then the judge goes through the various other issues of fact, finding that the judge's approach was unfair. So in 162, for instance, you have an issue about an email showing Mr. Bishop's familiarity with trust in client accounts, and the judge had drawn an unfair inference in relation to that. Same comment being made in paragraph 163. 164 was in the same vein. 165, a judge has made a finding of perjury against Mr. Bishop in relation to his evidence, and that was unjustified and not something that was actually put to Mr. Bishop. Then there's the point about the bonds. The evidence wasn't, in fact, that Mr. Bishop had said that the bonds were assets of the firm, and therefore that was Justice Reimer's view, not only wrong but seriously so. You can then see in paragraph 167 the judge is criticised by reference to the findings of dishonesty on the basis that the building blocks for the finding, this is paragraph 167 at page 3659, were fatally flawed. And then at 168, Justice of Appeal Reimer looks at the position overall and says the judge didn't stand back with sufficient objectivity and ask, was it more probable than not that Mr. Bishop was actually acting dishonestly? And that was very much by reference to motive. Is this something a bank manager would really do? What was the motive for him doing it? And you can see that being taken up at page 3660. He says, is it credible a account manager who was knowingly assisted the brothers, for instance, would make a suspicious transaction report in relation to tax evasion? What motive could Mr. Bishop have for his alleged dishonesty? So those are the sort of points that Justice of Appeal Reimer was making in this case. And then he concludes at paragraph 170. In my judgment, the combined effect of a judge's errors, namely his treatment of the expert and other banking evidence and the errors just discussed, raise a serious question as to the soundness of his ultimate finding. In my judgment, his order cannot be allowed to stand. So the consequences of the judge's errors in the way he approached the evidence led to the findings being overturned. He then turned at paragraph 174 at page 3662 to the disposition of the appeal, which is obviously very relevant for present purposes. And he says that he would allow the appeal and set aside the judge's order. He says, I've also considered whether I would go the further distance of also dismissing the claimant's claim, decided it wouldn't be appropriate to do that. I've explained why the judge fell into error in material respects and the consequences of his decision that the judgment shouldn't be allowed to stand. But then he went on to say, but I also consider that this court is in no position to decide that this is a case which was inevitably destined to fail. Accordingly, to dismiss the claim would be to deliver an injustice to the claimants. I consider the right course of action is to allow the appeal, set aside the judge's order, and order a new trial before a different judge.
Mr. Mobley-Smith, is it quite unusual to spend the first 20 minutes of an appeal looking at the detail of other cases?
Well, the only reason I want to look at this particular case is because it's the same Court of Appeal, it's the same judge, it's the same issue, yes, which was dishonest assistance. The same sort of errors made by the judge were made in our case, and yet it has a completely different outcome. Well. That's the reason. It was only that case, and I agree entirely. Nothing more need be said.
Okay.
What we say is the correct approach, and we accept that there's no authority putting it in quite these terms, is that what the appellate court seeks to do is to determine whether, by reference to the surviving factual findings and the undisputed evidence and any proper inference that can be drawn, that there are enough findings or factual conclusions to determine the issues in the case. If it can't determine those issues, the matter has to be sent back for a retrial. And in particular, where the issues depend on credibility, the appellate court's in no position to determine any issues of credibility. Hasn't seen the witnesses. And in relation to the approach taken in the Giska case, in our respectful submission, it is delivering an injustice to the claimants if the claimants are visited with the failings of the judge at first instance. So those are my comments on the legal position. If I can then briefly turn to the facts. Our claim is actually straightforward. There are a very limited number of documents you need to look at, and in fact a limited number of passages in the cross-examination that are relevant. If I could start by taking you to one of the key documents, which is the credit application made in 2005. You find that in bundle, page E 1805, which is bundle 5. You'll see it's a credit application. It's got a date at the bottom of 27th of October 2005. And this contains two relevant statements at page 1807. Statement, and this is made by a statement made by Mr. Shaw, who was the relationship manager. He says, it would also appear that on occasions client and office funds are not segregated, but segregation is not a requirement under current Gibraltar legislation, and we actually do not follow UK best practice adopted by some local competitor practices.
I'm sorry, where are you reading?
Sorry, I'm reading from page E1807.
Yes.
And towards the bottom of the page, there's a paragraph that starts whilst, and it's the last sentence of that paragraph.
Yes,
sorry.
I'm with you. Thank you.
And then,
There's a point made against you there that in your own time you might like to deal with, where Mr. Shaw is saying segregation is not a requirement under current legislation.
yes,
He couldn't be thinking that non-segregation was a criminal offence, because he couldn't be thinking, well, criminal offences are fine now, or stealing clients' money is fine now, but next year it won't be. And so that is said to be, correct me if I'm wrong,
yes.
a clue into what he thought segregation meant.
Certainly that's what Justice of Appeal Reimer was saying. The reason why that is perhaps an inappropriate way of looking at it is because it all depends on what Mr. Shaw considered to be improper. He obviously doesn't consider it to be a breach of legislation at this point. But he does say non-segregation. From the perspective of the time of the trial, he says, non-segregation is something that I must report. It's a breach of the bank's policy. It's a breach of the requirements of the Financial Services Commission in Gibraltar. I must report it.
It's an ambiguous word, isn't it, Mr. Movalis?
Well, it is, except in the context of this case. What are the possibilities for non-segregation? And the possibilities can only be that money that belongs to clients is put into an account where money belongs to the firm. There's no money going from the office account into the client account. It's only going one way. So you therefore have an account that has client money and office money in it. That's the first point. The second point is, in this particular case, the office account was invariably overdrawn. So any transfers into the office account inevitably involve the appropriation of the client's money to reduce the overdraft of the firm.
Well, if they were debts due, there's no problem about it.
If they were debts due, there's no issue of segregation at all. It's not a question of non-segregation. It's simply a transfer of money from the client account to the office account to settle a liability.
The client had no further interest in them.
Of course, exactly, my lady, yes. Yes.
They're not, then they should be segregated.
Precisely, my lady, yes. And if you were saying there's an issue of non-segregation, it's not best practice, it's going to become unlawful next year, you're obviously not talking about money being put from the client's account properly into the office account. You must be talking about something that's improper. And of course, this is in relation to 2005. You get to 2006, and we'll come to this in a moment. The first thing that happens in the 2006 application is a statement saying the law changed at the beginning of 2006. And so therefore, from Mr. Shaw's point of view, on his analysis of the law, it's actually wrong because there isn't any legislation that's relevant. But on his analysis, at the beginning of 2006, he has a situation where it's now unlawful to be transferring non-segregation, so it's not separating client and office money. And yet, as you'll see in a moment, he's prepared to countenance that situation continuing. So Justice of Appeal Reimer's sort of black and white. It can't possibly be because otherwise he would be countenancing something that's unlawful. Well, he does exactly that in 2006. I'll come to that in a moment, if I might. So anyway, you have here the 2005 application and the comments made by Mr. Shaw in that application. You then have the response from Jersey Credit. I don't know if you fully comprehended essentially when RBS and NatWest merged, the credit function that had been in Gibraltar was moved to Jersey, and therefore we're now reporting to individuals in Jersey. Mr. McLean is one of those individuals, and he responds in a sanction summary sheet that's at page 1815 of Bundle 5. And he sees an issue about segregation as one of the main concerns, and you can see that on page 1815, 3 paragraphs from the bottom. He says, the lack of segregation between client office funds is worrying but remains legal until next year. Hopefully the next annual review can confirm segregation of funds it will need to. So Mr. McLean is seeing this as being an issue that's going to involve something that will become unlawful the following year, and it needs to be resolved. And he imposes a condition that there's confirmation that segregation is taking place, and you can see that at page 1820 if you turn through. So that's 2005. You get to 2006, and you can see the comment made by Mr. Shaw there at page 1922. The application starts in 1921. And this is essentially a rerun of the 2005 application, but updated.
Sorry, can you give me the page?
Yes, of course. It's page 1921. And the relevant paragraphs at 1924. And there you can see, he says, historically it appeared that on occasions client and office funds were not segregated, but segregation was not a requirement under Gibraltar legislation. Marachi
Which paragraph?
Sorry, I do apologise. It's the paragraph at the top of the page.
I think it is,
And it's halfway down. I do apologise. Does my Lord see a sentence that starts historically?
yes.
Historically, it appeared that on occasions client and office funds were not segregated, but segregation was not a requirement under Gibraltar legislation, and Marachi didn't follow UK best practice adopted by some local competitor practices. On the 1st of January 2006, new Gibraltar legislation was introduced, making it a requirement to segregate client and office funds, and hopefully future accounts will confirm that appropriate practices are now being followed. Our recent experience has seen an improvement in the management of client funds. So now you have a situation where you have something that is now unlawful, and Mr. Shaw says in his evidence, we'll take you to it in a moment, that non-segregation is something that has to be reported.
Can I see Mr. Shaw's signature on this?
It's an electronic document. It's posted on an electronic system, so I don't think you actually see his signature, but there's no dispute that it is his document. And you'll see from the evidence in a moment that he comments on that. So you can see what he's saying is there is an improvement. And that was something he was cross-examined about. And if you have volume 3 to hand, which deals with the transcripts, you can see it's at page 1251. And the internal page number is page 60. E1251, yes. So you should have day 4, part of day 4 of the trial. Indeed, yes. Just at the bottom of that page, line 24. So I'm asking him about what he means by an improvement. And he says, I say better, it's not 100%, it doesn't now happen, but it's better. Now, of course, that raises the question, well, what's better, what's improved? And what has improved is obviously the non-segregation, which is now unlawful. The 2006 application seen by Mr. Heward of the Credit Department, and you can see that happening at page E1916. Have that, these sanctions comments. He says, this is a difficult position to manage, and then moving through a history of not altogether satisfactory account conduct and unwillingness to share information with RBSI, and some doubts about the extent to which client funds are properly segregated. So he's picking up on the non-segregation that Mr. Shaw is reporting. And then he says this, I know that client account issues are a sensitive subject, but I agree with the need to ensure that customers are compliant with current legislation. Given the potential reputational issues surrounding this, please ensure Mr. Graham Smith is aware and supportive of these facilities, and he was the head of operations. So there's a recognition that client account issues are a sensitive subject, but there's a need that the customers comply with current legislation. Now, you recall in the 2005 application there was a requirement for confirmation of segregation of office and client accounts. Was a requirement in 2006 application as well. Nothing happens in relation to that. So our simple proposition is you've reported non-segregation. In the circumstances of this case, it can only mean that client money is being paid into an overdrawn office account and thereby being appropriated by the firm to reduce its overdraft. The position in relation to 2006 shows that that's continuing thereafter.
What is the significance then of it being overdrawn? I mean, if money is owed by clients to the firm, the fact the office account is in overdraft has what significance?
Well, the significance is if the office account is in credit, then if the client money is paid into the office account, you simply have a mixed fund of office money and client money.
Well, not if I'm talking about if it's owed to the firm.
So if it's owed to the firm, there's no issue of segregation at all. There's no issue of non-segregation.
No, and the fact it's overdrawn is neither here nor there.
Neither here nor there.
No, that was what I was...
But obviously, where it's not owed to the firm...
Yes, I see.
And it can only be not owed to the firm, because otherwise there's no non-segregation to talk about.
Yes.
So we have Mr. Shaw's response to non-segregation. And what he says is he got comfortable with the issue of segregation by analysing the Marachi's bank accounts.
Where are we now?
I will just summarise. Sorry, I'm just going to move on to documents in a moment. The relevant paragraph, which I was trying to summarise, is at page E914. It's paragraph 96 of his witness statement. So we're now in bundle 2, I think it is,
well.
and it's Mr. Shaw. Starts at page 878. So page E914, paragraph 96. So Mr. Shaw was very adamant that he got comfortable about the issue of segregation. And he identifies 3 elements that made him comfortable. Analysis of activity for the period to the 22nd of August 2005, information received from the accountants Baker Tilly, and discussions with the Marachi brothers. As to those items, he was unable to recall what Baker Tilly might have said to him, and there was no note of anything that was said, if anything was said. And so that didn't really go very much further forward. In relation to discussions with the Marachis, he accepted he could never have raised a subject as sensitive as non-segregation with the Marachis, so that never happened. So therefore, you were left with his analysis of the bank accounts. The investigation had been brought about because he had filed an excess referral report in August 2005 saying that he needed to investigate position. You'll find that at page 1785,
Page?
E1785.
Would be quicker if you could identify volume, Mr.
Yeah, I do
Martin,
apologise, it's volume 5.
If that's not inconvenient for you.
No, of course, I do apologise. So it's volume 5 again.
Which paragraph are we looking at?
And it's, there's a section in the middle that says Shaw Howard, and it's the last paragraph of that section. Where he says, as mentioned, I'm also investigating a number of transfers between client and office account, both with RBSI and the other bank in Gibraltar, and I need to understand how they manage their clients' clients' cash. I need to ensure they're not cross-firing or misusing clients' funds. So that was the basis for him carrying out an investigation. He accepted that that was a highly unusual thing to be doing in relation to a firm of solicitors. In due course, Mr. Justice Jack, the judge at first instance, took the view that this was the heart of the case, the investigation that Mr. Shaw carried out.
That's where judge's error creeps in by equivocating cross-firing and non-segregation.
Exactly, yes. What happened there, if I can just pass forward to that, was that he took the view that there was a conflict of evidence between Mr. Shaw and his immediate superior, Mr. Cartwright, whether or not a conversation had taken place about cross-firing. The judge decided that there was a conflict of evidence such as to need him to find whether or not Mr. Cartwright or Mr. Shaw had been lying.
Yeah.
Concluded that Mr. Shaw had been lying, but in actual fact there wasn't a conflict of evidence at all on that point. It was a slightly unfortunate development.
But standing back, this isn't of itself expressing a concern about non-segregation, is it?
No, it's expressing a concern about misuse of client funds. And so what you have to see is this is an investigation into misuse of client funds. The only place at which anything is reported is in the application we've just been looking at, which refers to non-segregation. Now, what Mr. Shaw said he was doing was comparing the turnover of the firm with the aggregate amount of transfers from the client account into the office account to see if the amount of the transfers was consistent with ordinary business activity. And you can see that in his witness statement at there's bundle 2 again. And it's page E916 and paragraph 102. And you see at paragraph 102, he says that's the exercise he's carrying out. Compares the turnover from the client account to the office account. Consistent with the level of business that was being undertaken was not concerning.
I wonder if you could keep your voice up, please.
Yes, of course, certainly.
Thank you.
What the bank disclosed in relation to that exercise was a single schedule, which you find at page 1789 in bundle 5. Page 1789.
Thank you. Yeah.
And you'll see there a document headed Funds into 293 account from 294 account. And you'll see there listed a whole series of transactions of a total 279, 271. But you'll also see a balance before and balance after given in relation to the office account, so you can see the impact of making the transfers. And if you look 3 down, you can see a round sum transfer of £20,000, converting a negative balance to a positive balance, and similar entries 3 or 4 lines below that. There was an issue about when the period started, and you can see at the top of the page it says January to August 2005. Mr. Shaw said no, it started on the 15th of February. The relevance of that is in relation to the Euro account. The Euro account had a series of transactions where money was paid from the Euro client account into the Office client account in the period prior to the 15th of February, but after the 1st of January. You can see that in Bundle 8, at page 3084 to 3085.
But this purports to be simply a schedule of monies coming from the 294 account.
Exactly. And the reason I'm just taking you to the Euro account, which is the 135 account, is that you will see just very briefly at page 3084 and 3085.
Which is volume?
This is volume 8.
Now,
What are we looking at here?
You'll just look at the bank statements for the Euro account.
this is the Euro client account.
Euro client account, yes. I just want to show you very briefly.
Was there a Euro office account, or were amounts converted?
The amounts were converted, and you can see on the sterling account the amounts converted into sterling. So 3084 it shows the transaction is slightly difficult to read because they go over the page divide on the electronic system, but you'll see 21st of January £112,000 being paid into the Office account.
Yeah.
Below that you'll see payments being made to the Christie Secretarial Services, which was the payroll company of the firm, so that's a transfer for the benefit of the firm. And that was £67,000. This is the 24th of January. And then over the page, you'll see a series of other transactions where significant sums of money are being transferred to the 293 account. The 2nd of February, 44,000. 11th of February, 44,000. And then payments to Christie, again, 33,000, 34,000. And towards the bottom of the page, 69,000. So that's just by way of example to show that a lot of other payments that were relevant to the exercise that Mr. Shaw says he was carrying out. As if he's going to compare the amount of money going into the Office account from the client account, it has to be all the client accounts, otherwise he can't carry out the exercise to see if it's a reasonable amount going across. That issue is relevant because Justice of Appeal Reimer suggested that Mr. Shaw need not have looked at anything at all beyond the Office account. That wasn't the point actually put to Mr. Shaw in cross-examination or in re-examination. But Justice of Appeal Reimer took the view that it's perfectly reasonable for Mr. Shaw only to have been looking at the Office account, but didn't consider whether or not that had any impact on the exercise he purported to be carrying out. Mr. Shaw said that the investigation, as I say, was one of the things that gave him comfort in relation to segregation. It's said by the bank, well, there's nothing to connect the exercise with what's reported in the 2005 application. But if it gave him comfort, it's obviously apparent that it's going to be something that is going to be reported in the application, and yet there's no reference to comfort anywhere in the application or indeed anywhere else. And in our respectful submission, it's inconceivable the two are not interconnected. Mr. Shaw's evidence in relation to the 2005 and 2006 application was he never once believed the Mirachis were segregating client funds or misusing funds. And you can see that if we go back to bundle 3 and the cross-examination.
What about in volume 3?
So we're in volume 3, and we're going to look at page 1251, so internal page 57. Where he says, line 19, during my time as relationship manager, as I've said, I never once believed that they were misusing client funds. And turning through to page 104 on the same document.
This is internal page.
Page 104 at page 1262. Bundle.
So 1262.
Line 4. I had no reason to believe from the investigations that I'd undertaken they were not segregating client funds. I raised an issue in 2005, clear in 2006. I'm saying as an improvement because any concerns gone away. And he says the same thing, similar terms at page 1247, internal page 43. Very top of the page, lines 1 and 2. I undertook activity and eliminated any concerns. Now, one of the problems that Mr. Shaw had was, of course, that Mr. McLean in 2005 and Mr. Hewitt in 2006 had seen non-segregation, realised it was a serious issue, and that it needed to be addressed. And obviously, if Mr. Shaw is right in saying he had no concerns at all about non-segregation, he should have been telling them, you've got it completely wrong, there's no issue about non-segregation, nothing to worry about. He says nothing of the sort to them. And his only explanation is that it was his responsibility. You can see that at 1264 at page 111. Lines 19 to 20, responsibility sits with me. As I've said, I was comfortable with the position. The position develops in relation to the 2006 application. If you look at 1262, you can see it, internal page 101, he says, so maybe it wasn't closed in 2005, but in 2006 this is the first re-reference I make to the segregation of funds issue. And then he says further down at page 102, it's not an issue that remained outstanding, because if the issue had remained outstanding in my mind in 2005, I would have reported it. But it's not an issue that goes away. It might be a satisfactory position to take, but it doesn't mean that tomorrow's position won't be, because we could see some sort of recurrence. So it's never going to be closed. So,
Couldn't hear what you were saying.
so I'm reading from lines 13 to 21 at page 102. Sorry, I do apologise.
Please try to keep your voice up, because I'm struggling as well.
Sorry, yes, certainly. So it's page 102, and I was looking at lines 13 to 21, which is, I think, an important passage. Not an issue that remained outstanding, because if issue had remained outstanding in my mind in 2005, I would have reported it. But it's not an issue that goes away. It might be a satisfactory position to take, but it doesn't mean that tomorrow's position won't be, because we could see some sort of recurrence. So it was never going to be closed. There's always going to be an ongoing management of the client's relationship. And he's talking there about non-segregation, which he, after the 1st of January 2006, viewed as a criminal offence. Turning on to page
But,
105.
I mean, in that passage, is he saying anything more than, well, you can never completely close something off because some misconduct might occur in future?
Exactly, and he's
not
saying
it did.
he's not saying it did, but if there's a recurrence, he's recognising the fact that it had happened in the past.
Yeah.
And absolutely, but what he's also saying is it's a matter of the client relationship, it's managing the client relationship in circumstances what he's talking about is something that's unlawful on his view of the law, and obviously a breach of trust as well, and a breach of the FSC policy and the bank's policy. But that's what he's saying. He's saying it's a recurrence. And all that leads to a huge conflict of evidence as to whether or not he's to be believed when he says, I satisfy myself, there's nothing to be concerned about. Whilst at the same time saying in his applications there is non-segregation on occasion, and in these passages saying there's been an improvement, it's not 100%, things are better, again recognising the fact there has been non-segregation, and recognising here that it may recur. And they can't both be right. He can't have been satisfied if what he says here is correct. And the only way that can be resolved is by seeing him give his evidence and form a view as to the position. And that's what should have happened. Unfortunately, what happened in the first instance was the judge decided not to address the principal issue in the case, which is what was Mr. Shaw meaning? Was he acknowledging a misappropriation of client money by virtue of non-segregation? What the judge did was to approach the matter from the perspective of the investigation, and he saw that, as I say, as being at the heart of the case. You find it paragraph 168 of his judgment. We're now into bundle 9.
But just before we leave the cross-examination, was it put to him that if he was aware there had been non-segregation and that the only account in which there could have been mixing, which is the positive expression of the negative non-segregation, was an office account, and that account was overdrawn, and that meant there must have been misuse of client money?
Exactly, that was put to him in terms.
I'd like to see where that was put.
Certainly. It was put to him on a number of occasions.
Later, if somebody wants to chase it up for you, but I would like to be able to read it.
Yes. So I think I can probably find... I mean, it was put to him a number of times by me and by the judge, but that must be...
Yes, well, I mean, if you want to give me a note later on, I don't...
Yes, of course, yes.
I don't insist on it being gone through now.
Yes.
I would like to read
But
it.
that definitely was put to him. And basically his answer was, whenever that was put to him, is I never saw non-segregation. He never answered the question as to what the consequence might be. What a page number. So we'll come back to that. So what did the judge do?
Why didn't you all highlight of using a word that was so ambiguous? Why not at the start of the trial submit to the judge, and hopefully the judge accepts? We won't talk about segregation. It's so ambiguous. Let's call a spade a spade.
Because the point we were making was it was a word being used by Mr. Shaw.
Quite.
He was using that word, and it could only have meant a misappropriation of client funds. And we were putting to him, that must be what it means. And every time we did that, he simply said, I never saw non-segregation. So he was using the term, and it's his own phrase.
Yes, it is.
And therefore, one can, I think, assume that he's using the phrase, when he says, I must report non-segregation, he's using the phrase in the same way as he's using it in the 2005 application. It's the same set of words. And one must assume that he's meaning the same thing.
Yes, okay.
Sorry, in relation to the judgment, which I was going to take you to, I was going to start at paragraph 168 of the judgment. It's in volume 9. And you see there that the judge says, sorry, page 3204. So instead of our case being a starting point and the issue about the meaning of non-segregation being a starting point, the judge leaps in and says, no, the starting point is the investigation that Mr. Shaw carried out. And that's really where it all starts to go wrong, starting at paragraph 168. And it goes wrong, first of all, by reference to the point my Lord Briggs raised in relation to cross-firing. Because essentially what happened in relation to cross-firing was the learned judge took the view that there was a conflict of evidence as to whether there had been a discussion with Mr. Bautista about cross-firing and resolved that against Mr. Shaw and found Mr. Shaw to be a liar. And he then considered whether he could use that finding to support other findings of dishonesty against Mr. Shaw. He considered Mr. Shaw as a witness, and you can see that at page 196, 197, in the context of the comparison between him and his superior, Mr. Cartwright. And you can see at paragraph 196 and 197, the judge makes some adverse comments about Mr. Shaw as a witness.
3215.
3215, sorry.
Thank you.
And 197 is another paragraph where the judge takes a view that the answers given by Mr. Shaw were evasive. So that we do have, therefore, some findings about demeanour. The next issue the judge made a mistake about was in relation to the Baker-Tilly meeting, a meeting with the accountants. The issue there was whether or not a note had been made. And you can see at page 201, paragraph 201, page 3217. The judge makes a finding that Mr. Shaw had lied about there being a post-meeting note, whereas what Mr. Shaw had actually said was he couldn't remember. So the judge has now made two mistakes about the evidence of Mr. Shaw. He then moves on to the question of the investigation and what Mr. Shaw had looked at. That's the analysis we looked at page 179. And he starts at paragraph 183 of his judgment, saying that what had been investigated by Mr. Shaw was obviously inadequate. This is page 3210.
Paragraph?
Paragraph 183. And then paragraph 184 is where he deals with the sterling client account. So 183, he's saying looking just at the sterling account is inadequate because you should be looking at all active client accounts if you're investigating whether there's been a misuse of funds. And in 184, he says there were matters that were potentially suspicious, and he refers to round sum transfers and bunching of payments. Then he then deals with the payments into the to the payroll company Christie at 185. 187, he says, if he'd looked at the euro account, we would have had concerns, and those are the transfers we looked at a moment ago. And then 188, he addresses the question of the exercise Mr. Shaw said he was carrying out. Comparing the turnover with the amount of money going into the client account, and then concludes that there were various things that would have put a reasonable banker on notice: absolute levels of transfers, short period from the euro account to Marachi entities. And so there you can see creeping in the same error that you see in relation to the Jiska Bank case, namely the judge making himself an expert in relation to banking practice. He then makes a comment about the US dollar account at paragraph 189 and says that's another area where Mr. Shaw would have discovered highly suspicious activity, because the American Express bills of one of the Marachis was being paid from the client account. He then moves on to his conclusions about client account at paragraph 202 and what Mr. Shaw looked at. And he says he doesn't believe an investigation into the sterling client account would have been sufficient. And he concludes that an experienced banker would have been spurred into continuing his investigations. That's the bottom of paragraph 202. Then looks at motive, and this is where the judge, with respect, gets a little more creative, and deals with the fact that Mr. Shaw didn't file a suspicious transaction report in relation to his suspicions firm. He says once he'd identified a misuse of client funds, he was justified and obliged to make such a report. He picks up in paragraph 205 the comments of Mr. Heward about client accounts being a sensitive issue. And then makes the point that whistleblowers are not always thanked. The justification of Mr. Shaw not acting. In 206, he says the misuse is in the hundreds of thousands, not in the millions. Mr. Shaw will be able to see it as dipping. In other words, he was seen the Marachis taking money for immediate liquidity purposes rather than stealing money with no prospect of making repayment. That's paragraph 206. Mr. Shaw could have hoped, paragraph 207, that if he persuaded the firm to run its accounts properly, the monies borrowed would in due course come back and matters could be put on an even keel. Bottom of 207. Mr. Shaw brushed the issue of non-segregation under the carpet in 2005. Difficult to revive the issue. And then 209, then creates a theory as to what Mr. Shaw might have been doing in relation to the investigation, his explanation for investigation in the context of the trial, and brings into play the Bautista investigation as an invention of Mr. Shaw to explain why he didn't investigate further. He had been given an explanation about cross-firing Bautista, and that meant he wouldn't have needed to investigate further in relation to the client accounts. That was never any part of the claimant's case. And then he concludes at paragraph 210 that Mr. Shaw did look at other client accounts and that on the balance of probabilities he would have discovered evidence of misuse, and therefore he was dishonest in allowing the firm to continue to misuse client funds. And then he provides an alternative that he didn't, in fact, have knowledge of misuse, plain a suspicion of misuse, he stopped his investigation at that point, and therefore it was Nelsonian blind eye knowledge of the dishonesty. So that's what Mr. Justice Jack found. We then turn to the Court of Appeal. There were 5 points taken on appeal. First, in relation to the Bautista conversation, that a finding that Mr. Shaw was lying was unfair because it was never put to Mr. Shaw. Secondly, it's factually wrong. Thirdly, in relation to the Baker-Tilly meeting and the note, that's factually wrong because Mr. Shaw had never said he had produced a note. The judge was wrong to have looked beyond the 294 account, and his findings of dishonesty were against the weight of the evidence. So those are the grounds that were raised. I can take up the Court of Appeal judgment at paragraph 137.
Page.
Page 3296. Justice of Appeal Reimer first of all upholds ground one, which was the fact that the allegation of lying should have been put to Mr. Shaw. And then, in relation to the factual inaccuracy of the findings about that conversation, he deals with it at paragraph 147, page 3300, where he says that the findings in relation to that conversation were of such primary importance in the overall determination that it's impossible to conclude without that element of the findings that the outcome of the trial would be the same. Regard the judge's wrong finding sufficient to enable the appeal to succeed. That's paragraph 147. So at this point, the judge has said error 1 and error 2 is sufficient for the appeal to be allowed. In relation to the Baker-Tilly meeting and whether or not there was a file note, paragraph 150, he records there was a serious mistake by the judge in finding Mr. Shaw had lied about that. But at paragraph 155, he accepts that what the judge was saying was that, or might have been saying, was that Mr. Shaw had not obtained any comfort from the meeting with Baker-Tilly, and that he was allowed to make that finding. That's paragraph 156. But then he qualifies that by saying, although the judge would have been entitled to make that finding, because he had tainted his views so much by the wrong findings in relation to the Bautista conversation and Baker-Tilly, it was an unsafe conclusion. And you see that in paragraph 157. So then at paragraph 158, he deals with the position in relation to the accounts. And this is where he forms a view so first of all, he accepts that the judge was entitled to conclude that the period Mr. Shaw was looking at was from January to August. That's paragraph 161. Then at paragraph 164, he takes the point about the judge making himself an expert in relation to banking practice. That's paragraph 164.
Was it explored in evidence? The schedule we saw,
Yes.
the reference to January to August was manuscript.
Yes.
Yes.
Was
Was it explored when that was written on it?
It was. Not as to when when it was annotated by Mr. Shaw. I don't think that itself was explored. But what was explored was the fact it was his handwriting, and why would he put January to August if it started in February, in the middle of February?
But it was identified as his handwriting, put on at some stage.
Exactly, yes.
Thank you.
So that was where we got to in relation to that document, and that's dealt with at paragraph 166, and this is where Justice of Appeal Reimer says that, in fact, he may only have looked at the office account and nothing beyond that. And that, as I say, was not something actually explored in the evidence. And then, if you turn on, you can see at paragraph 169, there's no evidence that Mr. Shaw had looked at any of the other accounts. And that's repeated in paragraph 170. And he then criticises the judge about paragraph 172 for his comment about an experienced banker being spurred to investigate. The same point again about the judge having no expert evidence to that effect.
Not one of those points which is so obvious as not to lead.
No, because what he was saying was the payments had been bunched, and there was no expert evidence to say. There was expert evidence about ransom payments, but no expert evidence about that issue, which the judge acknowledged, but nonetheless made a finding that that was suspicious. The judge similarly rejects suggestion that Mr. Shaw would have looked or noticed the payments to the payroll company. That's paragraph 173. And then paragraph 176, he concludes that those various issues raise a serious question as to the soundness of the judge's ultimate finding that Mr. Shaw did investigate other client accounts, a risk of contamination, the fact he had made previously findings of dishonesty against Mr. Shaw, that he was a liar and so forth, paragraph 176.
Is there anything wrong with what Justice of Appeal Reimer said in 176 about the risk that he made this great conclusion, that the judge made this great conclusion about looking at other accounts after having made these erroneous findings, and that there was contamination?
Yes.
Is that a reasonable
Yes.
line for Reimer J.A. to have taken?
We accepted that it's clearly possible that his view was tainted.
Yes.
And for that reason, we haven't appealed the Court of Appeal's decision on the basis it was wrong, because we accept to that extent the Court of Appeal was entitled to make that finding.
Yes. I mean, you're obviously coming on to this, but going through my mind, one of the points is you didn't get up and say in the Court of Appeal, I'm afraid there are errors in the judgment here, I can't defend them. Nevertheless, there are aspects that weren't explored, and that with great respect to the Court of Appeal, you can't explore them. And so there's got to be a retrial. On the contrary, you obviously said to yourselves, the Court of Appeal can explore them. Hence the cross-appeal, whether it was strictly a cross-appeal or whether it is what in England and Wales they would call a respondent's notice, that doesn't matter. But you laid all these points before the Court of Appeal as if you conceded that they could deal with them, and they did. So what do you say to that?
Well, in relation to the points, what we said to the Court of Appeal was these points haven't been addressed by the judge. The judge has gone down this route of looking at the investigation and not our case. And we are saying he should have looked at our case. And what we were saying is additional reasons for supporting what the judge has said.
Yes.
And you can, by reference to the points I've been making earlier about non-segregation and what Mr. Shaw says about non-segregation, you can conclude that Mr. Shaw did know what was going on, essentially.
Yes.
And we said that to the Court of Appeal. The Court of Appeal said they weren't in a position, because what we were asking him to do, once all the other issues of dishonesty have been overturned, we were essentially asking the Court of Appeal to make a final determination as to dishonesty. And it wasn't in a position to do that, because that is obviously not something that an appellate court can do. And so that was the problem for the Court of Appeal. We thought if it was simply supporting, if all the other findings of dishonesty hadn't been overturned, we were then supporting those findings of dishonesty with these additional reasons to give the Court of Appeal comfort as to why it could uphold the judgment. But once it had knocked all those down, we were then left with a rather stark proposition that the Court of Appeal should make a finding of dishonesty, and we accept that the Court of Appeal wasn't in a position to do that. It's at that point it should say, we can't do that, this has to go back for a retrial. These are issues that haven't been explored.
I'm not sure you ever said that of your own motion. We rather get the impression it was the Court of Appeal saying, well, disposal, if we're against you, basically, Mr.
Yes.
Mobley-Smith, should there be a retrial or should we just allow this appeal?
Yes.
Whereupon you said retrial.
Yes. And I'm saying it again.
Indeed. Thank you.
Yes. But as I say, what we were trying to do in the Court of Appeal was to support, as best we could, the judge's finding. The Court of Appeal says we can't, and we accept here that because it involves the finding of dishonesty, neither the Court of Appeal nor the Board could make that finding.
Yes.
And therefore we need a retrial. In relation to the cross appeal, as we turn on to what happens there, that's at page 195, sorry, paragraph 195 to 6.
Just before you get there, you have to challenge, don't you, as wrong, what Reimer J.A. says at the end of paragraph 182.
Yes, because yes,
if he's saying it's incredible
yes.
on the evidence that there is
yes.
that Mr. Shaw would have found out about a misapplication of funds and not reported it to his superiors.
Yes.
Then I mean you have to persuade us it's not incredible. It's a tribal issue which hasn't yet been tried.
Exactly. And we do that by, as I say, by reference to the 2006 application and Mr. Shaw's attitude towards the 2000. Here's something unlawful. Here is non-segregation. I'm happy to proceed. He doesn't view it as plundering. That's a very emotive word adopted by Justice of Appeal Reimer. What he's viewing is occasional non-segregation, occasional essentially borrowing money from the client account to overcome the short-term problem of the office account becoming overdrawn. And indeed, on the schedule we looked at, you saw the three columns. There was the column of the payments, a column of the account before, and a column of the account after transfer. And what he says in the course of the cross-examination is one of the things that would have alerted him is a payment from the client account to the office account to clear an excess. And if it's clearing the excess, maybe that's something he saw. I mean, our position is what Mr. Shaw has said is non-segregation. The only purpose of the investigation is looking at Mr. Shaw's explanation, and the purpose of the investigation is essentially to show that there were circumstances in which he could have reached the conclusion that there was non-segregation.
Can you remind me, when did Mr. Shaw say he compiled the schedule that we find on E1789?
In August of 2005, I think it was August. And he says it must have been after the 22nd of August, because that's the last date on the schedule. My Lord's absolutely right. In relation to paragraph 182, we do depart from Justice of Appeal Reimer's suggestion that it would have been viewed by Mr. Shaw as plundering.
Would it also be correct that you have to disagree with what Justice Reimer said at 173, where having dismissed the bunching, allegation. He said there was nothing in the fact of the transfers from 294 to 293 to raise Mr. Shaw's suspicions.
Well, in relation to that, as I say, there is the fact that the schedule does show, and I think I pointed out to you, that circumstances where the excess is cleared by a transfer from the client account. So to that extent, we would say there are potentially suspicious circumstances. But in terms of our position, we're not saying, we're not pinning our colours on the investigation. The investigation, as I say, is the bank's explanation, Mr. Shaw's explanation of how non-segregation doesn't mean non-segregation. And what we need to show is that there was an opportunity for Mr. Shaw to have seen something which resulted in him reporting non-segregation. Just in the context of how Mr. Shaw viewed things, you can see at volume 3, page 1187, pages 40, internal pages 41 to 44. I think it addresses my Lord Briggs's question.
Thank you.
Page 1187. Was Mr. Shaw asked whether the consequence was that the money was being misappropriated? Line 10 on page 41. Coming back to the question I was asking a few minutes ago, the scenario you were faced with was the client funds into client accounts and overdrawn office account. Yes. So in terms of the funds, there wasn't an office fund and a client account, simply client funds and a client account, and overdrawn office account. That's correct. So when you're talking about lack of segregation in relation to client and office funds, what you're really meaning is client funds being paid into the office account. And then see on the following page, so page 43, what I was really trying to get to the bottom of is when you refer to lack of segregation, what you're really meaning is a potential for client money to be paid into the office account that's overdrawn. And he says there is always that potential, yes. And that's what the concern was, wasn't it? When you say concern, you mean references I made in documentation. And then he says, when I say it will come later for documentation, I think I recorded potential concern, wish to satisfy myself there was no misuse. And then at page 1244, you can see at pages 29 to 32, 31, the same point being raised. Page 29 in particular. Sheer fact, money's moved from client to line 13 on page 29. If the office account's overdrawn, that's the effect, isn't it? It's the effect. It has the effect on the day of a transfer to reduce the amount of overdraft. I don't really see what that means. The money has disappeared. What would happen the following day if they paid £1 million in? Has it reappeared?
What page was that?
That's page 1244, and it's internal page 29.
Oh.
And you can there see he says, in relation to paying money into the office account, where we're looking at page 29, doesn't really see that means the money has disappeared. What would happen if the following day they paid in £1 million? Has it disappeared? So has it reappeared? So what he's recognising there or suggesting is that there's nothing wrong if the money is essentially borrowed overnight by the firm. And then on page 30, you can see he says, again, you know, if there's a trail here, they say you've borrowed client money. If someone said, if you borrow client money because you're short of funds and you put it back, is that acceptable? As a layperson, I'd say I wouldn't know, but I'm not qualified to make those comments. So essentially, he's leaving open the possibility that borrowing client money is not unacceptable.
You were reading from paragraph?
That's
page
30.
Page 30, thank you.
Line 16 down to 21.
Thank you very much.
Yeah.
And so we then move on to the disposition of the cross appeal. And it was on page, we're looking at, starting at paragraph 195.
I mean, have we looked at page 31 on 1244?
I've definitely, sorry, just question.
Line 12.
Time. Yes.
As a layperson, says Mr. Shaw, I would think it's not acceptable to borrow money from the client account if you're short and pay it back when you're back in funds.
Yes.
That's not a process I can ever remember discussing. So when you say he admitted seeing dipping into client improperly to borrow on a short-term basis, is that a fair summary of Mr. Shaw's evidence?
What I'm saying is sorry, if you look at the passage before that,
Yes.
he is saying he's not qualified to comment as to whether or not it is acceptable.
No, quite.
And then, my Lord's entirely right, he then does repeat it.
Yes.
And then the judge says there surely must be a problem with non-segregation, that in effect the firm would be borrowing from the client, which, as you said, is unacceptable. And his only answer was, I would never prove non-segregation during my time as relationship manager.
Yeah.
So the question is his comment there actually an honest response to the question? What he might be saying at the time of the trial, is that what he considered the position to be as at the time the transfers were taking place? Or was it something at that time he thought was maybe in a grey area, but something that was allowed to happen?
When you use the word dipping, sorry, it's a separate point, what is the aggregate sum which you contend was appropriated improperly?
Well, in relation to this period...
Yes, but simply Mr. Shaw's period.
Yes. In relation to Mr. Shaw's period, the answer is we don't know, because what we're not saying is you can point to any particular transfer and say this is unlawful borrowing of client money. We can't say that. What we can say is he's acknowledged non-segregation. He's acknowledged that money has been improperly mixed. It can only have gone into the client account that's overdrawn. Therefore, there has been an inappropriate misuse of client money. And the only question in relation to these aspects is, was there something that he could have seen that would have led him to that conclusion? But my lady's entirely right. We can't say this amount was misappropriated at this stage. I mean, overall, at the end of the day, when the Marachas were prosecuted, I think it's 28 million or something was found to have been stolen.
Just through this bank?
For two banks.
Ah.
Yes. There's the JCPC Bank and this bank.
Very well.
But I think
how much was stolen via the respondents in this case?
Sorry.
How much did Mr. Magner lose? Mr. Magner?
The overall sum, it's about £9 million. Yeah, euros, sorry. But sorry, I appreciate the time ticking by. In relation to the notice of cross appeal, he deals with that paragraph 195 onwards. And he makes the point that the judge didn't attach a sinister sense to the words non-segregation. In paragraph 196, he told to meant that was the firm misusing client money, but inconsistently with that, if you turn over paragraph 200, you can see he says the judge did consider non-segregation to be a dishonest misuse of client money. Paragraph 201, he makes the point that it's unfortunate that Mr. Shaw didn't say precisely what he meant by segregation, non-segregation. Suggested in 201 that he wasn't pressed to do so, but you've seen the passages he clearly was pressed to do so. And then he addresses my submissions at paragraph 202. And in 203, Justice of Appeal Reimer accepts that Mr. Shaw's answers in relation to non-segregation were, he produced no very impressive answers. You can see at paragraph 203. He then picks up what Mr. Shaw says about if he had seen misappropriation of client funds, he would have reported those immediately. That's 203. Example that Mr. Shaw gave of mixing, which obviously has no relevance at all to the case, which is if you put £50 in client money and £50 of office money into one account, there would be non-segregation. Well, that's all very interesting, but of no relevance whatever to the facts of this particular case. And for some reason, Justice of Appeal Reimer found that an appropriate answer to the question. Paragraph 205, he says, though the judge made critical comments of Mr. Shaw on non-segregation, ultimately, anyway, in positive terms, he didn't rely on any of the points in his assessment of Mr. Shaw's honesty. And so there the judge is recognising a fact that our case was not being, or was not addressed by the learned judge. And then at 205 he says what the cross appeal is really asking for in the light of the fact that the judge's other reasons for dishonesty have been flawed is for the Court of Appeal to make its own finding that Mr. Shaw's evidence about non-segregation was untruthful. And he says 206, the Court's in no position to do so. Uncertainty as to what the references to non-segregation meant.
So just, I do apologise, it's my fault. In which paragraph does the judge recognise does the appeal judge recognise that the case you're making hasn't been answered?
Paragraph 205, but he didn't address the question of non-segregation. So he refers to the points just summarised, which are the points that were being raised in the cross appeal, the points I've been making to my lord. And then he concludes in paragraph 209, while the judge made sideswipes at Mr. Shaw about non-segregation. Ultimately, they didn't lend us any assistance. He says, difficulties the judge's findings of dishonesty against Mr. Shaw were flawed from beginning to end, taken away as nothing left upon which the court might build some substitute substructure, enabling respondents to maintain their judgment. So there he's saying the Court of Appeal is not in a position to make findings of dishonesty against Mr. Shaw in the way it would have to if it allowed the cross appeal, and therefore the judgment fails. I should say. He then deals with disposition in paragraph 211, points out that both parties had addressed him in relation to retrial. And then he says, paragraph 212, 213, it would not be just to order a retrial. First, the respondents do not challenge the judge's rejection of their case against the bank in relation to the other individuals other than Mr. Shaw. And he says it would be unjust to direct a retrial enabling a reopening of the cases against them. Any retrial would therefore have to be substantially reconstituted. And then secondly, he says the respondent shouldn't, I see no reason why the respondent should be given a second chance to make good their case against Mr. Shaw. They adduced what evidence they had against him and he answered it. The judge made findings of dishonesty that he did against Mr. Shaw. They're unsustainable. I see no proper basis upon which another judge should be asked to try the same. Now, in relation to those points, first of all, point one is not a reason not to grant a retrial. It's simply saying that in Justice of Appeal Reimer's view, the scope of the retrial should be limited to only dishonesty allegations being made against Mr. Shaw. So therefore we're left with the second basis, which appears to be we've adduced evidence against Mr. Shaw and he's answered it. Well, obviously, how he's answered it and whether he's answered it in a credible fashion is something that hasn't been explored or been determined by the judge or by the Court of Appeal. The fact that dishonesty findings were made against Mr. Shaw is really neither here nor there. They've been made and they've been overturned. Doesn't impact on whether or not there should be a retrial if there are other bases on which we can succeed and should succeed. And finally, he simply says, I see no proper basis on which the judge should be asked to retry the same issue. In terms of the proper basis, coming back to our original proposition, the proper basis is that there are aspects of the case, fundamental to the case, which have not been determined either by the judge at first instance or by the Court of Appeal and cannot be determined because it depends on the credibility of Mr. Shaw as to whether or not his explanation for the written documents he's produced, that on the face of it record a misappropriation of client money in breach of trust.
Do we see in documentary form in any place how you put it to the judge at first instance, this argument about non-segregation?
Well, you can see it in the, quite where it is in the, it will be in the transcript somewhere, it's probably in.
What,
could we perhaps look up the reference?
In your written submissions, for example?
I'm sure it is, yes.
Yes, well, I'd welcome perhaps later on sight of,
yes,
of what was put to the judge.
Yes, but in terms of our case was by reference to, our pleading case was by reference to the documents, to those documents.
And it's essentially the document you took us to earlier this morning.
Precisely, yes.
You say that fundamental aspects of your case against Mr. Shaw have not been determined by ... the Court of Appeal.
Or by the Court of Appeal. So, yes.
Yes, I'm just looking at that part of what you're saying.
Yes, sir.
In paragraph 209, we're on 3335. The comment liner doesn't he determine that there is no basis upon which the case you're running in your cross appeal could succeed?
I think he's saying there's nothing left to support the judgment.
Well, yes, but to support the judge's order.
Yes, so in order to be able to maintain the judgment, the Court of Appeal needed to be able to make a determination about whether or not Mr. Shaw, or to make the determination that Mr. Shaw had meant misappropriation of funds in his 2005-2006 applications. Actually, the Court of Appeal only looks at 2005, not 2006. But essentially, what the Court of Appeal wasn't in a position to do was to determine that issue. And, yes.
I think I'm gently suggesting to you that the Court of Appeal did determine that issue, and you're really having to say they got it wrong, aren't you?
Well, if this is viewed as a determination of that issue, then yes, of course I am saying that. But what I'm saying is, I think what he's saying is that looking back at paragraph 206, in 206, where he says, we're not in any position to make the finding. I think he's saying that on the basis of what we were saying, essentially, as he says in 205, is that Mr. Shaw was dishonest. The Court of Appeal has been invited to make a finding of dishonesty against Mr. Shaw. And it couldn't do that. And therefore, when you get to 209, what he's saying is, we couldn't make that finding, and therefore there's nothing left to support the judgment.
The other interpretation is that they omitted to take into account the case made on the documents pleaded in paragraph 31, and that they were just dealing with the point about segregation as being founded on the findings of dishonesty which they were setting aside.
Yes.
They were not saying, were these bank records, the reports and the spreadsheet, inherently capable of sustaining a case on dishonest assistance.
And I think the other point to make is that Justice of Appeal Reimer only focused on the 2005 application. And as you've seen, the 2006 application and Mr. Shaw's answers in relation to the 2006 application actually make the case much stronger, because there's an admission that the matter is improving and therefore must have existed in the past. I'm conscious of the time. It's now nearly 12:15, which I think I was going to stop. What I haven't done is to address the points my learned friends have raised in their discussion. Perhaps I could do those in my submissions in reply. And I think we then keep to the timetable.
Yes, we'll stick to the timetable. Mr. Simpson, do you follow? Mr. Mitchell.
I'm going to deal with 5 topics, time permitting. Firstly, some introductory remarks or some big picture points. Secondly, the law and the test to be applied, the width of the discretion. Thirdly, an overview of the reasons for refusing a retrial, which is Fourthly, into the weeds a little, if we have to, I'm going to address the examination by Mr. Shaw of the client account, which is rather grandly called the investigation. So that's the 4th topic, investigation. And fifthly, I will deal with non-segregation, or the cross-appeal point. Can I start with some introductory remarks, I think of which there are 7. The first is that the court would have observed that this appeal against the decision not to grant a retrial is brought against the background that there is no appeal against the decision by the Court of Appeal to set aside entirely the findings of dishonesty made by the judge, which were thoroughly unsound from start to finish, and not just in relation to the Bautista lie and the meeting note. So no appeal from that. Secondly, there is no appeal either from the Court of Appeal's decision on the cross-appeal, which, as my Lord Wilson pointed out, would perhaps be better characterised in English vocabulary, at least, as a respondent's notice. There are further reasons for upholding the judgment, as opposed to a cross-appeal in the sense of saying the judge was wrong. But the second point is there's no appeal from that respondent's notice cross-appeal either. Therefore, the appellants do not dispute the Court of Appeal's conclusion that there wasn't an alternative sound basis for dishonesty. And the appellants had a right to appeal both those 2 decisions. So this is a lack of courage and conviction with respect. Instead, we have, in relation to the Court of Appeal's decision to allow the appeal and not to allow the cross-appeal, a smattering of points from a learned friend, some of which mentioned for the first time today, quibbles here and there with particular paragraphs which make up part of the Court of Appeal's decision or decisions on the appeal and cross-appeal. And that's unsatisfactory. The third point is that there is a particular problem for the appellants today by reason of the Court of Appeal's ruling on costs. And that particular point may not have resonated hitherto. But the Court of Appeal made a ruling on indemnity costs. Sorry, it made a ruling on costs and awarded indemnity costs from which there is no appeal. Permission to appeal was sought but was refused. Now, the Court of Appeal ordered indemnity costs of the dishonest assistance claims, the relevant claims we're talking about, on the basis that they were speculative and without foundation.
Yes, the point really is that by making that award, they were in effect saying that the documents did not of themselves afford a basis for a finding of dishonesty, even if Mr. Shaw was confused as to what he meant by non-segregation.
My Lord, with respect, yes. They were speculative and without foundation. The speculative bit is that obviously Mr. Magner has no evidence to give about the bank's dishonesty or otherwise. So the speculative bit is, here are the documents in the bank's disclosure. Read them and infer dishonesty, please. And the without foundation conclusion is, as your Lordship correctly points out, the Court of Appeal's conclusion, having looked at those documents, the inferences which naturally arise, the question whether they're consistent with honesty or dishonesty, the overall probabilities, etc. Now, the Court of Appeal on indemnity costs did not make an order for indemnity costs on the basis that some judges do or did, which is that if you bring a claim of dishonesty and fail, you pay indemnity costs. The Court of Appeal were quite careful to say that's probably not the law. They made it on a safer and more sound basis, if I may say so, that there was nothing of substance in the claims. Can I just take your Lordships and your Ladyship to the cost judgment so you know it exists, as it were? It's in electronic bundle.
Just before you do that, could you just explain for me why it's going to be such a problem? Because the normal effect of a retrial, surely, is that the costs order may include some order with respect to the costs of the first trial.
Not so, my lady, with respect. There is no appeal from the costs orders made by the Court of Appeal. If there's a retrial, there is a retrial and we start again. But the conduct, the unreasonable conduct of the first trial and its subsequent appeal is a matter which is, as a matter of record, there and there.
But your answer recognises the retrial could take place independently of this issue.
The retrial, if there is one, will take place independently, if I've understood your Ladyship, in the sense that it will now take place, as it were, de novo.
If there were one, I'm not giving any indication, but I just can't see quite where this point is taking you.
Well, the point is that the appellants in this case are faced with a finding which they have not appealed, and therefore they are bound with and by, namely that the Court of Appeal have decided that the claims for dishonest assistance were without foundation.
But they've clearly argued this morning that the conclusion was not well founded.
And I'm raising the question as to how they can say that the judge's discretion on indemnity costs, which is a matter for discretion, which was made on a certain basis, which can't be challenged. They can say, on the other hand, the judge's discretion on a retrial can be challenged when fundamental to both, and as part of the Court of Appeal's reasoning on a retrial, was that the claims lacked substance. That wasn't the only reason, of course, the Court of Appeal.
I think Lady Alden's point is simply that were we to allow the appeal, even on the limited point of retrial, it would usually follow that the costs order made attendant upon all those disposals might have to be looked at again. In this case, the same result on costs might well be adopted. But in principle, when an appeal is allowed, the costs become reviewable, don't they?
Well, my lord, if the point is only, and forgive me if I was being slow, if the point is only that we could look at them, or we may need to look at them, or are they reviewable? And
Yes.
Obtain the court with that.
Yes, very well.
Ordinarily, we wouldn't, in granting leave to permission to appeal on the merits of some point, separately grant permission to appeal against the costs order that had been made below.
Well, Lord, Lordship would be the better judge of that. As I understand it, there isn't an appeal against the costs order, but if that's something we should look at or might need to look at, I'm happy with that.
But getting back to your third point, were you inviting us to construe the Court of Appeal's substantive ruling in the light of what they were saying about costs?
Well, it's not a question of contractual construction, but one is looking at the substantive ruling, which is essentially two paragraphs, 212 and 213, and where they say, particularly in 213, in a very succinct way, that they don't think it's proper to let the appellants have another go. They are drawing on their views on the merits, which they've set out at length in the previous 209 paragraphs, and which they also, and can I just give your Lordships and your Ladyship a reference, they also say a little bit more about in the cost judgment, and that's paragraphs
So which paragraphs?
18, 19, 20 and 21,
Okay.
which is E3351 onwards. Perhaps I can, it's not all the paragraphs I've mentioned, so I can just identify the relevant bits. It's the first sentence of paragraph 18 at 3350, that the outcome of the appeal was that the case presented at trial failed, and it's the last bit of paragraph 19. In reality, it's the outcome of the allegations of dishonesty failed.
Is that follows from what we saw in the main judgment?
Indeed. So, in answer to my Lord Hodges' question, it's to be read together, and these are postscripts or coda to the substance of the substantive judgment. Yes. 20 and 21. I don't think you need to read beyond 21.
No, but my point in relation to 20 and 21 really is this. Insofar as the Court of Appeal was addressing the cross-appeal and the argument that's now being presented that these documents with which the appellants opened give rise to a triable case. Does 20 and 21 say anything in that regard?
Well, Lord, I'll come to, it's my fifth topic, which I call non-segregation or cross-appeal. Yes. And our position is that there is no loose end, as it were, or no issue which fairly needs to be looked at again. That's the pithy submission, and we rely upon, in the main, as you might expect, the substance of the main judgment, but undoubtedly these additional paragraphs by way of code as well.
Thank you. And we were in point 3 of the...
That's point 3 of 7. The fourth point is this, that the Court of Appeal was able to resolve the appeal and the cross-appeal, and I would add the issue of costs as well. In other words, the merits of the claim for all purposes, on the basis of the documents, the contemporaneous commercial documents, together with the inferences that could be drawn fairly from them, and were able to ascertain whether or not those documents and other undisputed facts were consistent or not consistent with honesty. It being a broad proposition that if you're asking a court to draw inferences of dishonesty, you have to point to a fact which is supportive of dishonesty and is not consistent with honesty. You've got to show something to get that inference off the ground. So the Court of Appeal were able to resolve what they resolved on that basis. And this is not a case which, as your lordships and ladyships can see from the judgments, plural, where there was a clash of evidence, a clash between rival accounts of oral evidence as to what happened. It's not a Chen type of case, if one wants to put a label on it. This isn't a case where the Court of Appeal needed to, nor did it, make a finding of primary fact as to whether Mr. Shaw was honest or not. They resolved it on a different, more traditionally appellate basis. And that's entirely in accordance with the guidance given by Lord Justice Robert Gough, as he was in the Ocean Frost. When you look at cases of fraud, you should base yourself on the documents. That's a summary, rather inadequate one, but the gist of it. And also Mr. Justice Leggett, as he then was in the Guestmin case, which is a more recent articulation of the point that in commercial cases, perhaps other cases too, but commercial cases was the context, one should be looking at the probabilities that appear from the documents, the overall probabilities, and not on demeanour, i.e. whether you like somebody in the witness box, which is not very reliable. So that's the fourth point. The fifth point is that the appellants took a deliberate and tactical decision in the Court of Appeal not to challenge the judge's acquittals of the other 6 witnesses. And those other witnesses were Mr. Shaw's predecessor as relationship manager, Mrs. Lester, his successor, Mr. Ramaj, who was also his assistant, and then a number of individuals in the credit department sitting in Jersey. And those acquittals were not merely not challenged in the Court of Appeal, but they were relied upon in the Court of Appeal by the appellants. They were being relied upon by these appellants because they helpfully supported the judge's conclusion that Mr. Shaw had kept the fraud discovery to himself. That's what the judge found. The judge found that Mr. Shaw, had discovered the fraud and buried it. The acquittals weren't challenged because they were helpful to support the judge and his conclusion that they had indeed been buried. So quite deliberate and quite tactical. There's a lot of criticism today about the judgment, and I'm the last person to disagree with the criticism about the judgment, but in the Court of Appeal, these appellants sought to uphold it and fight for it very hard and support it, and that was one of the reasons why they didn't challenge the acquittals. That's the fifth point. The sixth point is a similar one, but by reference to the retrial. The claimants did not seek in the Court of Appeal a retrial in their appellate pleadings or submissions, either in the alternative or at all, and that was quite deliberate. Because, as I think Lord Wilson remarked to my learned friend, their submission in the Court of Appeal was that the evidence was clear. They said it was clear in the sense that the judge was right, that was the appeal. Clear dishonesty as the judge found. Alternatively, they said for the cross appeal, the evidence was clear that Mr. Shaw had been dishonest for other reasons. Their submission was the clarity. Uphold the judge, or if not those reasons, then there are clearly other safe routes to dishonesty that the court can make. A submission on a retrial, it cuts across that somewhat. It suggests that, well, matters aren't clear, that it has to go back. And that was a clear tactical decision which was made. Mr. Magner is a professional gambler, and he, as it were, put his money on red, and it turned out to be black. They put all their money on persuading the Court of Appeal that there was clear evidence of dishonesty, either as found or alternatively.
You say he's a professional gambler. I thought he was an entrepreneur and owner of casinos.
Well, I didn't mean it disparagingly. He's an online gaming entrepreneur like many in Gibraltar are. It's one of the big offshore...
But not a gambler.
My lady, if I meant more than that, I certainly didn't intend it. But that was the point, that it was the submission and the tactics in the Court of Appeal was, in a sense, a gamble, because they did put all their money on, and that's the point I'm making, not personal to Mr. Magner, all the money on persuading the court that there was clarity of evidence, where a retrial, of course, admits of the submission that it's all unsatisfactory and needs to be looked at again. Hopefully, seventhly, if I've got the numbering right, of course, once it became clear, I think as Lord Wilson fairly summarised the moment, when it became clear that the bank would win below, and Justice Reimer, or it may have been the other members of the court as well, I think, said in relation to disposition, what would you say? Of course, Mr. Mobley-Smith, reading the tea leaves, like any professional advocate, sees the opportunity to say, well, of course, we'll have a retrial of all issues, please, in respect of all witnesses. And there then followed, which I'm afraid there's no record of the submissions, but there then followed approximately 2 minutes worth of submissions from Mr. Mobley-Smith, who I think was taken rather by surprise, and no doubt 2 minutes of equally incoherent submissions from me in response. But that's the basis and the moment that Lord Wilson was referring to as to how this has arisen. And it might provide some insight into why the first reason that the Court of Appeal gave for refusing a retrial was, well, hang on, this is terribly unfair, and all those acquittals that we've just spent 3 days, as it were, not looking at, and upon which you have relied for your submissions. So those are the introductory remarks. In terms of the second topic, which is the law, I may not just need to say an awful lot about this in light of what my learned friend said. It's common ground that the Court of Appeal had a power. We have identified the relevant provision in the Gibraltar rules, which, for the avoidance of doubt, we say is section 69(1). We set this out in our case at paragraph 32, although it's also at E 4278. So far as we are aware, there is no Gibraltar case law on the meaning of section 69(1) or indeed 2. But given its breadth, and this may be common ground, we suggest in our case that the test is the broadest one, namely whether the interests of justice would require a retrial or not. And that formulation, which appears in our case, picks up language used in some of the cases, such as the Privy Council case of Reed, and indeed the Court of Appeal case of White and White, which we mentioned in our case. So there may not be a dispute. My learned friend talks about the interests of justice, as it were, for the claimants, or for the appellants. But the question is a broader one. What are the interests of justice? What does justice require? Which, of course, considers the court's resources and both parties, not just a particular party. In our written case, I don't think it's necessary to go to it, but in our written case at paragraph 38, we mention the Privy Council case of Reed. That's a criminal case, but it's helpful, not that doesn't matter, because it's helpful because it sets out in the passages we have cited in paragraph 38 of our case the sorts of principles that would be taken into account by a court considering a retrial. It's the judgment of the speech of Lord Diplock. Let's then just give a reference to the actual case. It's E3674, which we can look at if you like, although the passages are cited in paragraph 38 of our written case. And I hope I can summarise the point briefly like this, which is that Lord Diplock was reluctant to set out, by way of straitjacket, as it were, a fixed set of principles. Rather on the contrary, every case depends on its circumstances. And it is a multifactorial, that's my phrase, not his, multifactorial question, taking into account all factors, circumstances, evaluating them, giving such weight as might be appropriate in any particular case. Those factors include, as he points out, paragraph 346 of the report, which we cite, the strength of the case, but that may lead to a different conclusion on a particular case. It may not be that important, but undoubtedly it's a factor that the court can take into account as a part of the evaluative process. We also refer to White and White. Again, I don't think I need to say more than is in our written case, which is the Court of Appeal decision. Now, against the background...
When you say a D, 39D, ordering a retrial is a remedy of last resort, and then you go on, a retrial involves a waste of time, White and White. Did White and White say it was a remedy of last resort, or is that your summary of it?
No, I think that is... I paused to check, but I think that is a recitation from White
is
and
it?
White.
Well, we can find that for ourselves.
I got 29. I got 29 of White and White is
Very well.
faithfully repeated in our submission. It's not a gloss. The other point, since my Lord raised White and White, is that, as we cite in that part of our case, Lord Justice Robert Walker, as he then was in that case, when applying the test of what the interests of justice require, made the point that in reality, what one is looking at is to check whether without a retrial some substantial miscarriage of justice would occur. The words substantial miscarriage of justice, which appear in our case, are also taken word for word from the White and White decision.
Yes, because in paragraph 29 to which you refer, he refers to the previous statutory test, which is retained in Gibraltar, and says this still applies.
Precisely.
Yes. The power is like the general approach to the exercise of the power is likely to be the same and at least as restrictive.
At least as restrictive, exactly. That's the point. So it's not just any quibble, as it were, that you might have about the trial process. It has to be a serious point going to the miscarriage of justice. Now, against that background, we emphasise, against the background of what the law is and what the test is, we emphasise that the issue on this appeal before this court, before the board, is not whether the interests of justice required a retrial or not. That's not the question. The question is not, as it were, de novo, did the interests of justice require a retrial? The question before this board, as a final court of appeal, is, did the Court of Appeal make an error of principle in deciding that a retrial was not appropriate? And that is a different, narrower question.
It's any of the grounds on which judicial discretion would be appealable, isn't it? So it could be a misdirection.
Your lady is absolutely right, but you're focusing on the point for this appellate court, this board, being a review of that discretionary decision. So you have to find an error of principle on traditional principles. I think that's my lady's point.
No, there are other grounds on which a discretion can be challenged apart from error.
Indeed, you actually mentioned misdirection, taking into account something that they should not have taken into account, ignored something that they should have taken into account. An error of that sort. And
it's an evaluation rather than a discretion, but you're not drawing a distinction.
I'm not drawing a distinction, and I may be analytically imprecise in not drawing the distinction, because in substance it's the same point. It's an evaluative exercise in the court's discretion, which can't be criticised in this court de novo. Let's have a debate as to whether there should have been a retrial, but the debate should be looking at grounds of appeal, what error of principle, if any. You might struggle to find clear grounds of appeal in this case, what errors of principle were made. My lady has already anticipated the next point I was going to make, which is that the Court of Appeal did have a wide discretion, and there's no suggestion that the court did not appreciate this or did not seek to apply that test, and we cite, again, I can do it economically, I hope, paragraph 42 and 43, the essential test and content of this court's review. And the point is that the appellate court should not be interfering, and that is the right word, with the Court of Appeal's decision unless there is a proper basis for doing so. What the test is not, I hope I've set out what the test is and then the fact that it's a discretionary or an evaluative exercise. What the test is not, which we apprehend the appellant may be saying, is, was the case destined to fail? Or is it bound to fail? That's not the test that the Court of Appeal should have applied, and nor did it. That's the test one applies on a strikeout. If you come along and ask for a claim to be struck out, the question is, very broadly, is this a case which is bound to fail? And if it isn't, it has to be tried. The question for a retrial is a much more multifactorial, evaluative exercise taking into all circumstances. You may have a case which you are sure may succeed if you did retry it, but that doesn't mean to say that it should be, because there are other factors to take into account. I say that at the risk of it being defensive, and I want to come to the facts of this case. This is not a case where we would say or accept there was anything left, as it were, to retry. But I just want to emphasise the fact that that's not the test for the Court of Appeal, let alone the test of this final appeal court in reviewing the Court of Appeal's decision. My learned friend mentioned, under the heading, I think, of the law, the Yiska case, or the Lavarello and Yiska case, which is the other dishonest assistance case that the judge tried and the Court of Appeal resolved. That's a very different case. And I'm conscious that I don't want to fall into the trap that Lord Wilson referred to about spending time on the facts of another case. But very briefly, the errors in that case made by the same judge were very different to the errors he made in our case. The errors that the learned judge made in Yiska was that he excluded from his consideration banking expert evidence and non-expert banking practice evidence entirely. Having done so, he made no findings on that banking practice at all. And then he coupled that error with imposing his own views. But the problem about excluding evidence, and it was very important evidence from the bank, to the effect that, well, you may say that these transactions are full of red flags and indicia of fraud, but can I just explain to you what a banker is expected to look for and see? That's essentially the banking evidence. Bankers are not detectives, they're not bloodhounds, they're looking for this rather than that. That's a very brief summary of the evidence, but that's the gist of it. Problems about excluding all of that meant that no findings had been made on it at all. And the Court of Appeal were being asked in the Yiska appeal by the bank, perhaps optimistically, for a dismissal of the entire action. So, if I just take that point a bit more slowly, the bank went to the Court of Appeal and said, the judge has got this wrong, but please, Court of Appeal, go the extra mile and not merely set aside the judge's findings of dishonesty, but also give me, the bank, a dismissal. And the Court of Appeal in paragraph 174, we didn't go to it, but it's the paragraph that matters. Sir Colin Rymer, Justice of Appeal, in that paragraph was considering the submission as to whether or not the Court of Appeal in that case could go that further stage. And it's in that context that he said what he said, which my learned friend referred to, which is, well, I'm not sure that the case is inevitably doomed to failure. So I'm not prepared to go that extra mile. The final point to note, therefore, is that it was common ground in Yiska, in the Court of Appeal, common ground that if you couldn't go the extra mile, there would be a retrial. And the bank in Yiska, the Yiska Bank, sought in their appellant pleadings, appellant's notice, a retrial in the alternative if they couldn't get the Court of Appeal to go that extra mile. So there's no actual real discussion in Yiska about the test for a retrial. The debate in 174 and the context for when the court says, well, is this case bound to fail, the context, forgive me, is the bank's submission that there should be a dismissal. So as we say in our written case, that's not setting the test to be essentially a strikeout test. It's dealing with a different point. Yes, my learned friend, Mr. Medcroft, points out correctly that it's not obvious, or I think not apparent from the 4,000 pages that you have, that the bank did seek a retrial in the alternative because you don't have that document. But I've seen the appellant's notice, and they did seek it in the alternative if their more ambitious plea for dismissal was not successful. I'm grateful. I wasn't going to say anything about Chen, although it's just one of a number of cases, and there are a few of them now in the authorities bundle, which all turn on their own facts. And it's a classic example of a case where there's a rival account given by two witnesses, a clash of evidence, unlike this case, where Mr. Ung, who transferred the shares, had a different view on the facts from Madame Chen, who received them. And the problem was that the judge didn't make any findings, or sufficient findings, about who was telling the truth, he having dismissed both parties' accounts. And so that's a classic example where the Court of Appeal simply could not resolve the case at all. But note that that was a case where they thought there was a proper basis for saying that one of the witnesses was dishonest and was wrong, in contrast to this case. But in our submission, although the appellants have added a lot of material to the authorities bundle, and we've gone through it, it's difficult to see those cases as being anything other than applications on their own facts of essentially a broad test and a discretion. So that was topic 2. Namely the law and the test to be applied and the width of discretion. And topic 3 was an overview of the Court of Appeal's reasons in the substantive judgment, paragraph 212 and 213, to be read with the coda, if that's the right way of putting it, of the cost judgment, 18 to 21. And this is the heart of the appeal. This is the reasoning from the Court of Appeal for refusing a retrial. And it's commendably brief and succinct and reflects, of course, the substance and length of the submissions made by Mr. Mobley Smith. I know that, me as well. It's E3336 of the electronic bundle, right at the end of the judgment, as I'm sure the court will appreciate. The first point to make is that in the first sentence of 212, if I can use the paragraph numbers of the judgment, they have applied the right test. It would not be just to order a retrial. They've applied the general question of the general test of what the interests of justice requires, a question of justice. So there's no doubt that they've identified the right test. Then the first reason, which is the next sentence, that they rely upon in 212, is that it wouldn't be just to allow the appellants to open up a case against the bank relying upon the activities of the 6 acquitted officials. And we see, with great respect to my learned friend, no answer or adequate answer to that point. These acquittals were accepted, not challenged below, and utilised by way of support for the judge's theory that Mr. Shaw buried and didn't share knowledge of the fraud. There is no challenge, therefore, there was no challenge, therefore, to the judge's conclusion that they should be acquitted. There's no error of law suggested. There was no error of law suggested. And it's no good with respect, in this court, at least in the written case, to make a somewhat half-hearted attempt to quibble about Mr. Cartwright, perhaps, or Mr. Hewitt, the two people, well, query whether those acquittals were quite right. It's a very half-hearted attempt in the written case, I don't think deployed orally. That's not appropriate. We're here to review the Court of Appeal's decision on the retrial, which was set against and in the context of those acquittals having been made and not challenged. And that first reason that the Court of Appeal give is, in my submission, a sufficient answer to the entire appeal. And that's because the pleaded case and the case advanced at trial, and sometimes they're not the same, but the pleaded case and the case advanced at trial was that all the bank officials were dishonest together under the direction of the evil Mr. Cartwright, who was the senior man in Gibraltar above the relationship managers.
I'm not sure we get that from the particulars of claim, do we? Where do we get that?
It's a later document.
I
think that's, with respect, a fair observation. I find the particulars of claim, paragraph 30 and 31, quite difficult to understand. The case advanced at trial through cross-examination, as recognised by the Court of Appeal, and I think this is common ground, was that Mr. Cartwright was the rotten apple. That was the phrase used at trial. And Mr. Cartwright, I'm sure your lordships and your lordship recall, he sits, as it were, above the relationship managers and below Mr.
It's a document at the end of the same bundle as the particulars of claim. It's a reply to a request for further particulars.
Oh, my lord, we'll get that. I'm grateful. We'll get that reference back of. So the point is the pleaded case and the case advanced to trial was that everybody was dishonest. So those in Gibraltar and those in a senior position in Gibraltar and those sitting in Jersey running the credit function who effectively called the shots in relation to Gibraltar banking business at RBS. They were all dishonest. They all knew about the fraud for the reasons set out in the pleading. And Mr. Cartwright in particular had suborned, as it were, the relationship managers on the front line from any attempt to do anything about it.
Yes,
Your lordship may have had in mind E190.
Whereabouts is that?
That would be bundle 1A.
Yeah.
I
think it's
actually
228.
It's a later one.
Right.
You find it, yes, it's E228.
The best, yes, that simply provides the identification, does it not? The best place to find it is with respect in our case, where we attempt to summarise the case as put at trial. It's 12 and 13 of our prison case.
Yes, but your point was that the pleaded case was one which asserted that the bank officials operated with a spider at the web, as it were. But I was also looking at the answers given in that document, and it does say Mr. Shaw and or Mr. Ramage. It doesn't say Mr. Cartwright. At the centre of the web. Anyway, so the pleading point.
Well, I was careful to say deliberately that the pleaded case and the case at trial, because there was a little bit of mutation in the pleaded case to the way it was put at trial, and I was not taking a pleading point. I was trying to reflect the substance of the way it was put to all the witnesses and to the trial judge, and was put on the basis that we summarise in paragraph essentially 13 of our written case.
Yes. I mean, the document I was mentioning identifies a number of bankers who are said to have had, or bank officials who are said to have had actual knowledge of dishonesty.
And that, I referred to...
Or blind...
or Nelsonian blindness, indeed. And I've referred to the six as a shorthand. In fact, as your Lordship will see from that very document, the allegation of actual knowledge, or blind eye knowledge, extended extraordinarily widely, and I think at trial it became focused upon those that turned up to give evidence. So that's how you get to the six. But if you look at the pleaded case, it was much, much wider.
Well, it's 8, isn't it?
And I suppose I can make this point, which is that if we are discussing a retrial of the pleaded case, we will be opening up a wider allegation than in fact was put at trial. But I suspect that wouldn't be how it was put again. My Lords, my Lady, that may be a convenient
Yes,
time.
very well. If that's convenient for you, very well. We'll adjourn until 2 o'clock.